Yes, Your Honor. The matter before the court is the case entitled State of Vermont against Eric Champagne, case number 24AP060. Representing the appellant, State of Vermont, is attorney Andrew Gilbertson. Representing appellee Eric Champagne is attorney Jason Sawyer.
Thank you very much. Good morning, counsel. We'll hear from counsel for the appellant first, of course. Please introduce yourself and your client and then proceed.
Thank you, Your Honor. My name is Andrew Gilbertson, and I represent the state of Vermont in this matter. And to begin with, I want to address one issue that came up at the last oral argument, where the court asked the state whether or not this was a preventative detention, or that Mr. Champagne's detention due to his inability to satisfy conditions was a preventative detention. And the state said it was. And it is in that Mr. Champagne was held because of his inability to meet conditions that will reasonably ensure protection of the public. But this term preventative detention it was used differently from this court in the past, where in the past this court has used the term preventative detention to specifically describe a hold without bail. In other words, being detained without any possibility of release. So we'd argue that's an important distinction and what makes a detention due to inability of satisfying conditions versus a hold without bail. And with that, the state is happy to entertain any questions from the court, or it will rest on its brief or reserve the remainder of its time.
All right.
Attorney Gilbertson, so I do have a question. The court understood, as I understand the state's arguments in the trial court for imposing conditions 4 and 11, they were directly related to public safety. Is that correct?
That's correct. That's what we asked for, and that's what I believe the trial court imposed them for.
Thank you.
But Mr. Gilbertson, at the time those conditions 4 and 11 were enacted, there was nobody available to be a responsible person for the defendant, correct?
That's my understanding, yes.
So doesn't that act as basically just a continuation of the hold without bail if it's very clear that he has no ability to have a responsible person take charge of him?
Well, I think the distinction is that that can change at any time, just like he could come up with a bail at any time. Is that he hasn't been able to find a responsible adult, but we don't know. Tomorrow he might find one. And so we would argue that it's not a continuation of a hold without bail because he has an opportunity to be released, even though he can't satisfy that condition. Just like someone held on $10,000 bail, as Mr. Champagne is now, has the opportunity to be released if he has the $10,000 bail.
Okay. I don't see any other hands, so we'll turn to counsel for the appellee. Please identify yourself and your client and then proceed.
Justices, good morning. My name is Jason Sawyer. I represent the appellee, Eric Champagne. It seems to me that a bedrock principle of our criminal justice system is the presumption of innocence, and preventative detention here really is a loss of liberty without any adjudication of guilt that this court has consistently frowned upon or said violates core Vermont values. It also affects his ability to his right to counsel and right to present a defense, because it is much, much more difficult to work with a client when they're in fact incarcerated. In this case, the court made a finding that he's been in now for, I think it's close to 790 days, and the court's finding is that he's not only hasn't made those conditions the responsible adult or responsible organization or a suitable residence, but that he has no prospect of making those. And I think just the time frame of well over 2 years at that time demonstrates that unfortunately Mr. Champagne, due in part to his substance abuse issues, significant issues, there's just nobody willing to take him in. And what I would say is this. I think the biggest problem with this is that it allows the state to circumvent the procedures in the Constitution and in 7554 and 7553. And you can actually you could put bail on the person, right? But then they could just be held because they can't meet those two conditions. And I think it becomes more problematic when you are looking at minorities, people who have disabilities, any group that has a more difficult time, one, finding housing, and two, finding someone to take them in. So in essence, I think this is preventative detention. It is punishment under Duff without any adjudication or any verdict of any kind of guilt. So I think in that sense, it does violate the Constitution. And in general, but I think especially in this case, as applied to the facts of this case, as Judge Griffin found them.
Okay. All right, counsel, thank you very much. How much time? Maybe we'll just turn back to counsel for the appellant. Do you have any additional comments?
I do not, Your Honor.
Any questions? I don't see any hands. All right, then thank you both. Please call a conclusion.